Can I just follow up on that one? Because it's to pick up on something you said earlier on, that I think it's what you said, the President, and I think it's in your evidence too, that President Obama was right to rule out prosecuting the CIA operatives as long as they were operating within the legal advice Iranian state may have been that was available to them.
In good faith.
In good faith, yes. Would you apply the same principle to UK operatives operating, for example, within the Michael Wood doctrine?
I think it must be right that in a situation of limited resources, why would you expend effort, energy and resource on the individuals who at the end of the day are not truly responsible for what has happened? I think the applicable principle has got to be to go up the decision-making process to the point at which the real decisions were taken, which is why I focused in particular on the lawyers and the policymakers rather than the people on the front line. What that I think necessarily requires as a matter of investigation, it's not clear to me who will do it, is what the interplay has been, without referring to any particular matter or case, between intelligence officers and government and others, and that's a complex issue on which we don't yet have.
So the Attorney General wasn't right to refer this to the police for an investigation?
Well, I think actually the Attorney General was rather brave to do what she did. I suspect she must have come under intense political pressure to do otherwise, but she was presented with a situation, and I don't want to get into the merits or the demerits of the facts, that is not an area I can go. She, as I understand it, was presented with material and exercised independent critical scrutiny in her prosecutorial function as a Attorney General, and I think that is the exercise she went through. It wasn't, I think, for her to decide whether it's best to put this to a general, commission.
But I mean, just sort of try and square the circle here. I mean, how could you possibly have a proper, open, so far as it can be, inquiry, public or semi-public inquiry, when you do have people at risk of prosecution, whether it be the individual humble CIA, MI6, MI5 operatives, or the lawyers, or ultimately, I suppose, ministers? How on earth are they going to cooperate with the inquiry when they're potentially at risk of prosecution?
It's a very difficult issue that was faced in a very dramatic way by South Africa back in the mid-90s, faced by Chile, and what they decided to do in roundabout and different ways was essentially begin with a non-criminal process, leaving open the possibility for criminal process to follow in due course, for essentially that reason, and because the decision-making was premised, I think, on the right approach, which is it is in the better interests of society as a whole to get more information out rather than less, sooner rather than later.
But the South African model, if I'm right, is that you got immunity for everything that you fessed up to, but you could still be prosecuted for anything you didn't tell them about.
Well, I mean, if you participated, essentially, and you participated fully and openly, essentially you were off the hook from criminal investigation. But if you failed to do that, then you were subject to criminal investigation. The same thing happened in Chile, and as you know, the truth process in Chile was followed eventually by criminal investigations and prosecutions and convictions.
But you would advocate basically a system of immunity for things that people own up to?
I've not thought about it in the context of this country. I've looked at it in the context of the United States, where Senator Leahy is going through exactly this internal process of questioning. And it's a really difficult question. I mean, it's not, I think anyone who says these are easy issues, I think is, in which it's black and white, is not really being straight. Senator Leahy has proposed some sort of truth commission to get all of the material out, in which there will be some form of limited immunity for a short period of time, but then depending on what came out, the matter may then go to a special prosecutor appointed by the Attorney General. Now that hasn't yet got off the ground, although there's some support for it. But it recognises the reality of the situation that you are addressing.
Well, I mean, if I were in America and I was in that situation, I'd just claim the Fifth Amendment. Why risk it?
I think it depends on what exactly are the rules of engagement, and the US.
We've heard that phrase before.
Yeah, the US is they're smart at coming up with rules of engagement that encourage people to to come forward. I think there's a lot of people who want to come forward in the US. I think, and I heard the question that was put in relation to Mr. Murray before, I suspect there are a lot of people in the United Kingdom who also would wish to come forward but are very uncomfortable doing so for a range of different reasons.
So we need to change the rules of the game again.
No comment.
Anthony.
Thank you very much. I'm sorry I missed part of your evidence, Professor Sands, but the focus of your questions from the committee have been largely on investigation and criminal prosecutions. But I don't think you've been asked about civil remedies in the United States. And I should know the answer, but I don't. Would someone who could show that they were a victim of serious ill treatment by perpetrators at a senior level have a civil remedy? I don't know whether the Alien Torts Act or otherwise in the courts of the in the federal courts of the United States, quite apart from these difficult questions about criminal prosecution.
I can answer that question by reference to the example that Mr. Timpson gave, because it has come up in the question of Mr. Arrar, the Canadian national who was intercepted at John F. Kennedy Airport and shipped off to Syria, where it is pretty clear, as the Canadians found, that he was horribly tortured. He went through the process in Canada. There's been payments of compensation, full public apology, full accounting. He's brought a civil procedure in the United States, and it has got nowhere because the federal judges have said this is a national security matter over which we cannot exercise jurisdiction, and astonishingly, I would say, the United States Supreme Court has declined to give cert to allow that case to be challenged before the Supreme Court. So at this point, the position appears to be that there is a national security bar to those cases of a civil character proceeding in US federal courts. Now, that may change with the change of administration. This predated the change of administration.
Would the same apply under the Bivens doctrine, the doctrine which teaches that where public officials knowingly...
There's a division in the House of Lords, I'm afraid. So we'll have to suspend. I think we'll probably come to the end of the evidence session.
I withdraw the question.
I think we'll come to the end of the evidence session anyway. So if folks in the House of Lords would like to go and vote, they get their skates on, and then they could come back, we've still got some private business to conduct. So